Dear friends, today we shall discuss the concept of defamation under Law of Torts. In today's deliberation, we shall discuss the concept of defamation, kinds of defamation, essentials of defamation, and finally we shall discuss its defenses. Let us first understand the definition of defamation. The right of each man during his lifetime to the unimpaired possession of his reputation and good name is recognized by law. Every man has a right to have his reputation preserved inviolate. This right of reputation is acknowledged as an inherent personal right of every person. It is a jus in rem, a right against the entire world. A man's reputation is his property, more valuable than other property. Indeed, if we reflect on the degrees of suffering occasioned by loss of character and compare it with that occasioned by loss of property, the amount of the former injury far exceeds than of the latter. The law of defamation is based upon the fundamental principle that the reputation of a member of society, the esteem in which he is held by it, the credit and trust it reposes on his intelligence, honor, and integrity, all these constitute a valuable asset for him and it deserves protection at the hands of law. The right of every person to the reputation which his conduct deserves stands on the same footing with the right of the enjoyment of his life, liberty, health, and property. A defamatory statement is one which injures the reputation of another by exposing him to hatred, contempt, or ridicule, or which tends to lower him in the esteem of right-thinking members of the society. Defamation is an injury to a man's reputation, and anybody who touches the reputation of another is said to do so at his own peril. It has been held by the courts that it may be defamatory to call a man hypocrite, a villain, a black sheep, or a habitual drunkard. Defamation is not limited to aspersions upon an individual's private character, but also includes disparaging observations prejudicial to his reputation in his trade, business, profession, or office. It is defamatory to impute to a trader or businessman or professional lack of knowledge, skill, qualification, capacity, or professional activity. Defamation in some cases is a criminal offense. It is an offense as defined under Section 499 of Indian Penal Code 1860, for which the offender can be punished under Section 500. The civil law of defamation is uncodified and rests on the English common law. The High Court of Jammu and Kashmir in Mushtaq Ahmad Mir versus Akash Amin Bhatt was required to decide whether a poor person who has not accumulated wealth has any respect and reputation in the society and consequently the right to protect it. Plaintiff instituted a suit in forma pauperis against respondent seeking decree to the tune of Rs 2 lakhs as compensation and damages. He alleged that statements published in respondent's newspaper stating that plaintiff was involved in commission of murder and is liable to be lodged in jail are libelous and false. The suit was dismissed by the court on assumptions that plaintiff's relatives were involved in criminal case and as such he cannot have any status or reputation in the society. It has also been assumed that as suit was instituted in forma pauperis, plaintiff having not been possessed of sufficiently worldly possession cannot have respect in society and cannot seek damages for defamatory statement. Setting aside the order of the court dismissing suit on said grounds, the High Court observed, "The respect and reputation of a person is not dependent upon how much wealth he has accumulated. A human being is entitled to lead respectful life in the civilized society. The human rights of an individual do pronounce that every individual shall be entitled to have respect in the society. Pronounced and professed values of the society do not state that only that person who has amassed worldly possession is entitled to respect and a poor man has no respect. If this assumption is followed and accumulation of wealth is made the touchstone for determining the reputation and respect one can have in the society, then a great disservice will be done to the entire society." Now, moving on, let's talk about the kinds of defamation. Defamation is traditionally classified into number 1, libel, and number 2, slander. Libel, it is a representation made in some permanent form, for example, writing, printing, picture or effigies, etc. Number 2, slander. It is the publication of defamatory statement in a transient form, for example, in spoken words or gestures. There is no difference between libel and slander under the Indian law vis-a-vis its being a criminal offence. Both are criminal offences under Section 499 IPC. But there are certain distinctions between libel and slander. In case of libel, defamatory statement is made in some permanent and visible form. Number 2, defamation is addressed to an I. Number 3, libel is actionable in itself. It does not need any proof of actual damage. Whereas, in case of slander, defamatory statement is usually made in some transient form. Number 2, defamation is addressed to the heirs. Number 3, slander is not actionable in absence of proof of actual damage. After discussing the kinds, let's shift our focus to the essentials of defamation. In order to establish the defendant's liability in the defamation, the following requisites must be proved by the plaintiff. Number 1, the statement must be defamatory. Number 2, the statement must refer to the plaintiff. And number 3, the statement must be published by the defendants. Number 1, the statement must be defamatory. A statement is defamatory when it has a tendency to injure a person's reputation. It is not essential that there must be some disparagement of the moral or intellectual character of the plaintiff in the ordinary sense. The test of the defamatory nature of a statement is its tendency to excite against the adverse opinions or feelings of others, such as hatred, ridicule, and contempt. In determining whether a statement is defamatory or not, the motive or intention with which it was used by the defendant is immaterial. Good faith or ignorance of the defamatory nature of the statement is no defense, for a man utters defamatory statements at his peril. The typical form of defamation is an attack upon the moral character of the plaintiff, attributing to him any form of disgraceful conduct such as crime, dishonesty, untruthfulness, ingratitude, or cruelty. But a statement may be defamatory if it intends to bring the plaintiff into ridicule or contempt, even though there is no suggestion of any form of misconduct. Thus, the publication of a humorous story which exhibits the plaintiff's portrait with that of a gorilla in a magazine, article, or the publication of a caricature of the plaintiff's personal appearance, or publishing a photo of the plaintiff's obscene posture are all actionable. Again, a statement is defamatory if it amounts to aspersion upon the fitness or capacity of the plaintiff in his possession or trade or in any other undertaking assumed by him. Thus, in Ridge v. English Illustrated magazine, defendants published a story which was shown to have been written by the plaintiff, a well-known writer. In fact, the story had been written by a grocer's assistant. It was a badly written story, and the people who read it would infer that the plaintiff's work has badly deteriorated. It was held that anyone reading the story would think of plaintiff as a mere commonplace scrubber. Plaintiff was awarded damages against the publisher. If the likely effect of the statement is the injury to the plaintiff's reputation, it is no defense to say that it was not intended to be defamatory. When the statement causes anyone to be regarded with feelings of hatred, contempt, ridicule, fear, or dislike, it is defamatory. In S.N.M. Abdi v. Prafula Kumar Mohanta, it was held that it is not necessary that the statement need not show a tendency of imputation to prejudice the plaintiff in the eye of everyone in the community or all of his associates. It is sufficient that the statement tends to lower him in the eyes of substantial and respectable group, even though they constitute minority of the total community. In this case, The statement published made certain allegations of misuse of muscle power by former CM of Assam, Mr. Mohanta. It was held to be defamatory. Mere hasty expressions spoken in anger or vulgar abuse to which no hearer would attribute any set purpose to injure character would not be actionable. But in Ramdhara versus Phulbati Bhai, it has been held that the imputation by the defendant that the plaintiff, a widow of 45 years, is a keep of the maternal uncle of the plaintiff's daughter-in-law, is not a mere vulgar abuse but a definite imputation upon her chastity and thus constitutes defamation. The defamatory statements may be either defamatory in their natural or ordinary meaning and defamatory in the light of facts and circumstances known to persons to whom the words were published. Thus, all statements can broadly be divided into two classes: statements prima facie defamatory and statements prima facie not defamatory. Number 1. Statements prima facie defamatory. The statement must primarily be understood in its ordinary and natural meaning, and a statement said to be prima facie defamatory when its natural, obvious and primary sense is defamatory. Such a statement is actionable unless the defendant can explain that the words do not contain a defamatory meaning. The burden of giving such an explanation which takes away the defamatory meaning from the words lies on the defendant. In determining whether the words in their natural and ordinary meaning are defamatory, the court must have regard to the mode, occasion, and context of the expression. The meaning of oral words can never be divorced from the speaker's gesture, tone of voice, and expression of countenance. Thus, when a lady says with a smile, "Mr. B, you are a thief, you have stolen my hair," one recognizes that to call Mr. B a thief in this sense would not be actionable. Number 2. Statements prima facie not defamatory. Sometimes the words which are not defamatory in the ordinary sense may nevertheless convey a defamatory meaning owing to the particular circumstances in which they are spoken. When a statement is thus prima facie innocent, but the plaintiff alleges a defamatory significance to it, B must in his pleading set forth the circumstances which make it actionable. Such an explanatory statement is called innuendo. Thus, innuendo is the explanation to be given by the plaintiff to bring out the defamatory meaning in the words to show that the words relate to the plaintiff whenever the words are prima facie innocent. In other words, the plaintiff has to prove an innuendo. The plaintiff is bound by his own innuendo, and at the trial he cannot fall back upon and some other secondary meaning instead of that which he alleges in his pleadings. Thus, a statement, "B is a good advertiser," is innocent in itself but carries a defamatory innuendo if published to the person who knows the intrinsic fact that B is an eminent member of the bar. Again, suppose M tells N that P is under the treatment of Dr. Z. This statement is not defamatory on its face, but if Dr. Z is widely known as psychiatrist, P may plead by way of innuendo that M has published to N that P is insane, since psychiatrists are concerned with mental disorders. In Cassidy versus Daily Mirror newspaper, the defendants published in their newspaper a photograph of one, Mr. C, and Miss X together with the statement, "Mr. C, the racehorse owner, and Miss A, whose engagement has been announced." In fact, Mr. C was a married man, and though Mrs. C and Mr. C were not living together, yet Mr. C occasionally came and stayed with her. Mrs. C, who was known among her acquaintances and the plaintiff, gave evidence that they had formed a bad opinion of her as a result of the publication. A majority of the Court of Appeal held that the innuendo was established and the words did reasonably bear a defamatory meaning. Number 2. The statement must refer to the plaintiff. In every action for defamation, the plaintiff must prove that the statement refers to him. It is, however, not necessary to show that the defendant intended it to refer to the plaintiff. The question in each case is not whether the defendant intended any such reference, but whether any person in whose hands statement would fall reasonably thought that the plaintiff was the person referred to. In T.V. Ramasubadayar versus A.M.A. Mohyuddin, the question was whether there was a liability in India for a defamatory statement published without an intention to defend the plaintiff. The court held that it was against justice, equity and good conscience to hold such innocent publisher liable, and the same rule was not applicable to India. Thus, it is not necessary that the plaintiff should be referred to by name. It may be under a fictitious name of a class. There is, however, a rule that if libel is made in the name of class, a particular individual can bring an action only if he can show that it applies to him. Thus, if a man wrote that all lawyers are thieves, no particular lawyer could sue him unless here was something to point to the particular individual. But if the class is so small or so completely ascertainable that what is said of the class is necessarily said of every member of it, then a member of the class can sue. Number 3. Statement must be published by the defendant. Publication means making the defamatory matter known to some person other than the person defamed, and unless that is done, no civil action lies. Communication to the plaintiff himself is not enough because defamation is injury to the reputation, and reputation consists in the estimation in which others hold him and not a man's own opinion about himself. Dictating a letter to one's typist is enough publication. Sending the defamatory letter to the plaintiff in a language supposed to be known to the plaintiff is no defamation. If a third person wrongfully reads a letter meant for the plaintiff, the defendant is not liable. When the father opened his son's letter or a servant opened and read a sealed letter meant for his employer, there was no publication by the defendant. When the defamatory matter is contained in a postcard or a telegram, the defendant is liable even without a proof that somebody else read it, because a telegram is read by the post office officials who transmit and receive it, and there is a high probability of the postcard being read by someone. When the libelous letter addressed to the plaintiff is, in the ordinary course of business, likely to opened by his clerk or by his spouse, there is defamation when the clerk or spouse opens and reads that letter. There is also publication when the defendant knew or ought to have known that the letter, although sent to the plaintiff, will be read by some third person. For example, it is written in a language which the plaintiff does not understand. In Mahendra Ram versus Harnandan Prasad, the defendant sent a defamatory letter written in Urdu to plaintiff. The plaintiff did not know Urdu, and therefore the same was read over to him by a third person. It was held that the defendant was not liable unless it was proved that at the time of writing the letter in Urdu script, the defendant knew that the Urdu script was not known to the plaintiff, and it would necessitate reading of the letter by a third person. Let's further move to the defenses to an action for defamation. The following defenses are available to the defendant in an action for defamation. Number 1, justification of truth. Number 2, fair comment. Number 3, privilege which may be either absolute or qualified. Number 4, consent. And number 5, apology. Number 1, justification of truth. In a civil action for defamation, truth of the defamatory matter is a complete defense. While as under criminal law, not only truth, but it must be shown to have been made for public good. The reason for the defense is that the law will not permit a man to recover damages in respect of any injury to a character which he either does not or ought not to possess. The defense is available even though the publication is made maliciously. If the statement is substantially true but incorrect in respect of certain minor particulars, the defense will still be available. The Defamation Act 1952 of England provides that if there are several charges and the defendant is successful in proving the truth regarding some of the charges, only the defense of justification may still be available if the charges not proved do not materially injure the reputation. Although there is no specific provision in India regarding the above, but the law is possibly the same as prevailing in England. Number 2, fair comment. Making fair comment on matters of public interest is a defense to an action for defamation. For this defense to be available, the following essentials are required. Number 1, it must be a comment. Number 2, the comment must be fair. Number 3, the matter commented upon must be of public interest. Since it is necessary that the comment must be related to certain facts, it is also essential that the facts commented upon must be either known to the audience addressed or the commentator should make it known along with his comment. Number 3, privilege. There are certain occasions when the law recognizes that the right of free speech outweighs the plaintiff's right to reputation. The law treats such occasions to be privileged, and a defamatory statement made on such occasions is not actionable. Privilege is of two kinds: absolute privilege and qualified privilege. Absolute privilege. Absolute privilege is an absolute defense, as under it no action lies for a defamatory statement, even though the statement is false or has been made maliciously. In such cases, the public interest demands that the individual's right to reputation should give way to the freedom of speech. Absolute privilege is recognized in the following cases. Number 1, parliamentary proceedings. Article 105, subsection 2 of the Constitution provides that the statements made by a member of either House of Parliament in Parliament and the publication by or under the authority of either House of Parliament of any report, paper, votes or proceedings cannot be questioned in a court of law. A similar privilege exists in respect of state legislatures according to Article 194, subsection 2. Number 2, judicial proceedings. No action lies against judges, lawyers, witnesses or parties for words written or spoken in the course of any proceedings before any court recognized by law. Even though the words were written or spoken maliciously without any justification or excuse and from personal ill will and anger against the person defamed, such a privilege also extends to the proceedings of the tribunals possessing similar attributes. Protection to the judicial officers in India has been granted by the Judicial Officers Protection Act 1950. The Council has also been granted absolute privilege in respect of any words spoken by him in the course of pleading the case of his client. Number 3, state communications. A statement made by one officer of the state to another in the course of official duty is absolutely privileged for reasons of public policy. Such privilege also extends to reports made in the course of military and naval duties. Communications relating to state matters made by one minister to another or by a minister to the president is also absolutely privileged. Number 2, qualified privilege. In certain cases, the defense of qualified privilege is also available. Unlike the defense of absolute privilege, in this case, it is necessary that the statement must have been made without malice. For such a defense to be available, it is further necessary that there must be an occasion for making the statement. To constitute the defense of qualified privilege, two things must be present. Number 1, the statement was made on a privileged occasion, that is, it was in discharge of duty or protection of an interest, or it is a fair report of parliamentary, judicial or other proceedings. Number 2, the statement was made without any malice. Number 4, consent. It is a defense that the plaintiff has expressly or impliedly consented to the defamatory material. It is a principle of law that the person who consents to an act that hurts him cannot claim compensation for his suffering. The court must consider all the surrounding circumstances to determine with exactitude what is and what is not assent to the publication of defamatory matter. Number 5, apology. At a common law, the fact that defendant had apologized for having defamed the plaintiff was no defense, but by the Libel Act 1843, the fact that the defendant made or offered an apology as soon as he had an opportunity of doing so could be given in mitigation of damages. Now, Section 4 of the Defamation Act 1952 gives wider protection in appropriate cases. Now, Section 4 of the Defamation Act 1952 of the English law gives wider protection in appropriate cases. It provides that if the defendant claims that the statements complained of were published by him innocently, he could make an offer of amends. If such offer was accepted by the plaintiff, he could not proceed against the defendant for libel or slander. In India, when there is an apology and an acceptance thereof, the defendant can resist the plaintiff's suit for damages for defamation. The publication of a contradiction and expression of regret by itself does not tantamount to an apology. Friends, that's all we have for you in today's lecture. Hope you have enjoyed it. Thank you very much.